सेव किया था ना?
मैं सिर्फ इसलिए गया था क्योंकि उसने मुझे कॉल किया, that's it. But listen तो.
Save it for someone else.
जिंदगी में सेव करना जरूरी है, मगर जब बात पैसों की हो, सिर्फ सेविंग से काम नहीं चलेगा। इक्विटी म्यूचुअल फंड्स में इन्वेस्ट कीजिए और अपने सेविंग्स को आगे बढ़ने का मौका दीजिए।
Mutual fund investments are subject to market risks. Read all scheme-related documents carefully.
The 5-judge bench of the Supreme Court has spoken on the Article 370 issue. It's a bunch of issues all tied in together. So we are just using the Article 370 issue like a headline. So five judges on the bench have all given a verdict with which they principally agree. Within that, there are a couple of variants that we'll talk about. Now, since these are complex legal and constitutional issues, I thought instead of me trying to break them down, reading them up and learning from my colleagues, Bhadra Sinha and Apoorva Mandhani, both of whom you know, they form our stellar legal and constitutional team. It is better to have them sitting with us and explaining the various issues to you, and also the reasoning that the judges have arrived at, and also what is the distinction between the view of two judges who've written separate orders as well, while principally agreeing with the rest. So we know that in principle, all the government decisions to do with the change of the status of Jammu and Kashmir, they've been held to be constitutionally correct. Am I right to say that?
Yes.
And second, the court has said that the election to the assembly, now election to the state assembly, has to take place by September 30. So by fixing that deadline for an election, in effect, they've also fixed an outside deadline to the reconstitution of a state, of the restoration of the statehood of Jammu and Kashmir, and the reconstitution of an assembly, or in fact constitution of an assembly, because it will be a new assembly. That is the essence of the judgment. So what we are going to do is that these two very well informed people, much informed than me, they will explain to us what the order means and the reasoning that the judges have arrived at. So to begin with, Apoorva will explain to us how did we get here, and then we'll get into other details of the judgment and the reasoning. And what will I do besides being the sutradhar of this conversation? I will butt in every now and then, mostly when it comes to political and strategic issues, and maybe at that point either Bhadra or Apoorva will ask me a question on that. So this is not a conversation that I am moderating or that I am leading. This is a conversation between the three of us, two specialists, one generalist. So Bhadra, Apoorva, please explain to us how did we get here?
Sure, I'll try to keep it really short and rewind back to August 2019 when we saw that there was the news flash that Article 370 was abrogated. How this was done is a very complex set of two orders that were issued by the president. For this discussion, I think just to give you guys a gist of what Article 370 was, in short, you just need to know two provisions, sub-clauses of Article 370, because these will keep coming up in the conversation. One was Article 370, subclause 1, subclause D. It's a mouthful, I know, but all it allowed was the president to apply certain provisions of the Indian Constitution to the erstwhile state of Jammu and Kashmir, because as we know, Jammu and Kashmir had its own constitution. It allowed the president to do so either with consultation of the state government or concurrence with the state government, depending on what provisions were being applied. Secondly, you need to know about Article 370 subclause 3. This is again very important. It allowed the president to declare the Article 370 itself inoperative. That is, it would cease to exist, but it could do so with the recommendation of the Constituent Assembly of the state of Jammu and Kashmir, which, as we know, did not exist anymore. And this was the impediment that was in front of the government to how to get away with doing away with Article 370. And that's what it did with the first proclamation that was issued by the president, CO 272 as we call it. The president did two things in it. Firstly, it said that it used another article altogether, Article 367, but I won't confuse you with that. It essentially said that Constituent Assembly in Article 370 subclause 3 would mean Legislative Assembly, and that order also, CO 272, also applied the provisions of the Indian Constitution to the state of Jammu and Kashmir. Then other things happened. Rajya Sabha then within hours recommended Article 370 should cease to operate. We should also remember that at this time the state was under President's rule, and then another order was issued by the President, CO 273, which essentially declared that Article 370 would cease to operate.
Yeah, so what had been happening was, it's something that I said also when this order was taken, that principally no party in India, no ruling party at the center wanted Article 370 to continue to be as strong as it was. In fact, every government at the center had weakened Article 370. So by 2019, Article 370, 35A and everything else that happened around it in terms of the autonomy of the state, it had moved a great deal from what it was, how it was defined in 1952. It had changed a great deal from 1950, 52. It had become a pale shadow of what it was. So the expression I used then was that what Congress governments had been doing all this while through a process of halal, the BJP carried out with like a jhatka. So they just use one set of laws, one amendments, one morning in parliament, pass them very quickly. And that is why this went into legal challenges, constitutional challenges, and there were 23 different challenges. Bhadra, will you explain to us the questions briefly? Now there are 8 questions. We don't have to explain all of them. 8 questions. So A to H, A, B, C, D, E, F, G, H. 8 questions. Those are the ones that Chief Justice of India, Chandrachud, read out as he started reading his order and his summary of the order.
Yeah, but before we talk about the 8 questions, as Mr. Shekhar Gupta pointed out, that the government of India over the years, as he said, through various orders was actually, implementing various laws in J&K. In fact, the court has gone into this historical background to rule conclusively that Article 370 was actually for the purposes of constitutional integration of Jammu and Kashmir with the Union of India, and that it has not been a piecemeal approach, but it has been a gradual process. So hence to say that, there was a malified intention on part of the President's notification would not be correct. And primarily on this ground, the Supreme Court has actually rejected the petitioner's contention, challenging the abrogation of Article 370. So let's get on to the questions. The first question, which was framed by the court, was whether the proclamation of the governor of 20th June 2018, which is to dissolve the Legislative Assembly, was actually constitutionally valid or not. But the court did not go into this issue because this challenge came very late in the day. It happened, this challenge was mounted after the abrogation of Article 370. The second question which was went into by the court was whether the proclamation issued by the President, that is the President's rule, whether that was constitutionally valid or not. The court did not adjudicate upon the validity of the proclamation also, for the simple reason that the petitioners had actually not made this prayer in the petition. So the Supreme Court refused to get into this issue. But at the same time, the Supreme Court looked into one interesting question, and that is whether there are limitations on the exercise of power by the President when a President's rule is issued. The court conclusively held that yes, there are limitations, and that, this President's rule should have a reasonable nexus with the object of the proclamation through which the President's rule is imposed in any state. And the decisions, it said, are also subject to judicial review, but the day-to-day decisions that are taken by the central government when a President's rule is imposed in the state, each and every decision, the court said, cannot be looked into by the court. In fact, it's a very important ruling, because it said that if the court gets into the day-to-day decision-making process of the government, it would actually put the administration of the state in a standstill.
Also, it will cause chaos.
That's right. Also, it will cause chaos. So as far as the proclamation is concerned, it did not go into the validity of the proclamation, but yes, it kind of talked about the exercise of power by the President, and the fact that the Union at the time of President's rule can actually also take decision, not just law-making decisions, but also non-law-making decisions. So the center's power to also take decisions when a president's rule is imposed in a state was also in a way upheld. Then came a very important question of whether the Jammu and Kashmir retained element of sovereignty or internal sovereignty. Now, the reason why this question was raised is because the petitioners challenged the abrogation on the ground that Article 370 is a permanent provision of the Constitution.
So, if I may ask you a curious question, what the petitioners implied was that because of Article 370, J&K, unlike other states in the Union, retained a degree of sovereignty of its own.
Yes.
So the court has said that there is no such thing. In fact, the expression the judges used was that J&K at the time of signing of the instrument of accession surrendered its sovereignty. I would have preferred if they had, one has to be really reckless to pretend to edit the judges, but probably a better expression would have been that sovereignty got dissolved in the Union as did the sovereignty of every other princely state in India as they joined the Union. So that's what they meant, that as a princely state joined the Union, their respective sovereignty got dissolved in the Union, and that happened with Kashmir. And since it happened with every other princely state, Kashmir was no exception. Is my reading correct?
Bilkul, perfect. That's the reading, and that is why the court went on to hold that Article 370 is a temporary provision, in view of the historical context as to how this article was actually introduced in the Constitution. It said that it is for the transitional purpose to provide for an interim arrangement until the Constituent Assembly of the state was formed. And as pointed out by Mr. Shekhar Gupta, it was actually this process and procedure was followed by every
Mr.
other.
Shekhar Gupta नहीं होता है.
fine.
अभी आप बहुत देर कोर्ट में बैठ के आई हो ना, इसलिए आपको सब
Sorry, Shekhar.
no court language है.
Okay. And as said by Shekhar, this was followed by all the other princely states. Another important aspect.
And I'd like to tell you something on this note, that Bhadra came to work with us as a trainee straight from college, 25 years ago? About 25 years ago in the Indian Express. So even then she would call me Shekhar, but now suddenly because she spent 6 hours in the Supreme Court today, she's got थोड़ा ज़्यादा इज्जत से बात कर रही है. But that's
okay.
Go ahead.
Okay. Another aspect which was pointed out by the Constitution bench is that this Article 370 actually finds a mention in that part of the Constitution which deals with temporary and transitional provision. Now, coming to another important question that was raised is whether the abrogation of Article 370 by the President was constitutionally invalid in the absence of Constituent Assembly. So, the court has said that it was not invalid, it was perfectly valid, and the fact that the Constituent Assembly is no longer present today doesn't mean that the President's power to declare the non-operation of 370 is taken away. So, they have really extensively dealt with this point, but it's very technical. So
let me try and simplify it. One way of putting it is that when Article 370 was put in, then the understanding that the court has given is that at that point it was needed. It was an instrument to bring the state into the union because of the unusual circumstances then.
Yeah.
But the idea was that this would be temporary, and in the course of time, as that union was more complete and it was seen that maybe this instrument was no longer necessary, a political call would be taken, and that political call could be taken in 2019, it could be taken in 2029, could be taken in 2039. The BJP took it in 2019. That is the point.
Yeah. So the next question, I think, Apoorva, would you like to address it? That is with regard to amendment to Article 367 and what the court has said.
Of course, Bhadra. So, like I mentioned, they used Article 367, which deals with interpretation of the Constitution, to indirectly amend Article 370 to clear the path because there was no Constituent Assembly. This was the only issue that the court held was invalid because it said that indirectly Article 367 couldn't have been used to amend Article 370, but it anyway said that this does not mean that the abrogation would be invalid on 2 pointers. It said that in any case, the president could have unilaterally issued a proclamation extending all the provisions of the Indian Constitution to the state of Jammu and Kashmir, as well as unilaterally could have issued an order saying that Article 370 ceases to operate. So even if it held this to be invalid, just this part of that CO 272, everything else it held to be valid.
The next question which the court had framed, Apoorva has already dealt with that, which is whether the entire Constitution of India could have been applied to the state of Jammu and Kashmir in exercise of the power under Article 371D. So as Apoorva pointed out, the President unilaterally could have not only abrogated Article 370, but also applied the entire Constitution of India on Jammu and Kashmir without any recommendation of the Constituent Assembly.
And the judges, if I understand this correctly, say that in any case under Article 371 A, B, C, D, etc., where any special provision has to be created for a state, that provision is available.
Yes. Yes.
That's about it.
So the next question was with regard to the constitutional validity of the Jammu and Kashmir Reorganization Act 2019, by which the erstwhile state of Jammu and Kashmir was bifurcated into two union territories. One is Jammu and Kashmir and the other is Union Territory of Ladakh. Now, interestingly, Shekhar, the court refused to, I must not say refused, but declined to get into this question, only because during the argument, Solicitor General Mr. Tushar Mehta had actually assured the court that full statehood of Jammu and Kashmir would be restored very soon, and that the current status of Jammu and Kashmir as a union territory is temporary in nature. So taking this promise into consideration, the court said that at the moment it is not getting into the constitutional validity of this particular act. And along with that only, it directed the Election Commission of India to hold elections before.
But you know what happened? When a government says this is temporary, temporary can mean anything because it's then infinite. Then it would depend on the wisdom of the government of the day, wisdom and discretion. So Article 370 was temporary. It took more than 70 years, right? So what the court has done in this case, the 5 judges, while they have accepted the government's argument that this is temporary, so they haven't gone into the division of the state on merit, they have said that, and nor have they set a deadline for the reconstitution or for the restoration of the statehood of Jammu and Kashmir, but they have said hold this election by September 30, which means before September 30, state has to be reconstituted, state has to be created again and or restored, statehood has to be restored, and the assembly has to be then reconstituted after a fresh election. So there is a deadline, and we know that by mid-March the general election will be over. In the general election, Jammu and Kashmir will vote for its parliament seats, Jammu and Kashmir and Ladakh, and within months of that then a state election will have to take place there. So this means 2 elections in Jammu and Kashmir and Ladakh within 6 months.
Right. So, and the last question which the court dealt with was with regard to Article 3, whether the government could have actually bifurcated the state into 2 union territories or not under Article 3. Now, Article 3 actually deals with the reconstitution of a state, where a state assembly's concurrence is needed. But with regard to this question also, the Supreme Court actually upheld the centre's contention that in the present circumstances, a state assembly's concurrence was not required.
Yes, so just to understand this better, when Uttarakhand, Chhattisgarh and Jharkhand were created, concurrence of the respective assemblies of undivided Bihar, undivided Madhya Pradesh and undivided Uttar Pradesh was sought. And only then the division took place, because Article 3, Apoorva, will you explain Article 3 a little bit?
Of course. So Article 3 talks about formation of new states and alteration of areas, boundaries of existing states, and it allows the parliament to do so by a law. Through a law, it can order formation of new states or new union territories, increase the area of state, reduce the size of a state. So it allows the parliament to do so. However, it has certain conditions. So it says that the parliament can do so provided that no bill for purpose shall be introduced in either house except on the recommendation of the president, and also such a proposal has to be referred to the by the president to the state legislature. So the proposal just needs to be referred to the state legislatures, and I think this is what the court referred to while dealing with this question as well, right?
Yeah, and while dealing with this question, what the court has actually said is that this is just recommendatory in nature. Hence, what it holds is that Parliament's exercise of power under this first proviso of Article 3 is actually valid because it was not malified.
So, let me ask you a question. Suppose any central government tomorrow or through Parliament of India decides to declare Tamil Nadu a union territory or divide Tamil Nadu into 3. How does that work? Then they don't have to check with Tamil Nadu Assembly?
So as far as carving out a UT out of a state, a particular part of the UT, a particular part of the state as a UT is a valid exercise for which you don't need, because in this particular judgment it has upheld the status of Ladakh as UT, because according to Article 3, the central government can actually carve out or probably earmark a certain part of the state as a union territory.
So tomorrow if the central government wants, they can carve out Kanyakumari as a union territory?
Yeah, but
Yes.
it just needs to seek views of the state legislature. That needs to be done.
And
Reference.
secondly, the exercise, it has to be determined whether it was a malified exercise or not. So the entire thing, what the court has actually based its judgment is on the fact that whatever steps have been taken, whether there is a reasonable nexus to the objective of the steps that have been taken. or not.
I would say, this is opinion, I would say that this goes into tricky area because you are living in under a majority government. Majorities can become bigger, and I'll be surprised if this was the spirit of this judgment, but we'll see, because there'll be a lot of debate on this, because this kind of a power in a federal republic with the center will be unsustainable going ahead. Having said that, the judges have been very clear that this is in the context of Jammu and Kashmir.
That's right.
Of course, also
Yes.
the court has left it open,
Open,
whether
yeah.
a state can be bifurcated or downgraded, so to say, if I may use that word, to union territories.
Yeah, because
that has been left open.
Because the question over the validity of the Reorganization of States Act is still hasn't been decided by the bench. They have left it open.
They've passed it.
That's right. They've passed it.
They've passed
They've
it.
passed it, yeah.
So now tell me, now we understand the basic judgment. So what are the two they are not dissenting views, but two different views that the two judges have written?
So they're actually concurring opinions,
Right.
both of them. In fact, Justice Sanjeev Khanna's opinion is just 3 pages. It's mostly agreeing with both the judgments, because he said, I can't just agree with one or disagree. I agree with both of them. As for Justice Calls, there are two pointers that I'd like to mention. Firstly, he said he largely agreed.
Sanjay
Kishan Kaul, right.
Yes.
So he largely agreed with the majority opinion, but the one point he found is that he said that the state of Jammu and Kashmir retained an element of internal sovereignty despite Maharaja Hari Singh signing the instrument of accession with the Dominion, and he said that Article 370 of the Constitution recognized this internal sovereignty by recognizing the Constituent Assembly of the state. That was the point of difference with the majority judgment, which, as Bhadra had mentioned, said that Jammu and Kashmir did not retain an element of sovereignty, but his conclusions are exactly the same, that the president could have issued the 2 orders that I just spoke about. Secondly, what he says is he has an epilogue to his judgment, and he speaks about Kashmir. He speaks about the history of Kashmir, the cultural, political history of Kashmir, and he says that
he's a Kashmiri himself.
Yes,
by the way.
that's right. So he spoke about the historical. He said that Kashmir Valley carries a historical burden, and a lot of the end part of his judgment deals with that. So he has recommended the formation of a commission, which is an impartial truth and reconciliation commission. He says that it's important for wounds to be healed. It's important for this commission to find out the truth of what happened there, for a common narrative, and to find out violations, human rights violations, at least since the 1980s, by both state and non-state actors. Although he's left it for the government to figure out when this commission will be set up, or what the terms of references will be, or how it will be set.
So Apoorva, you just mentioned Truth and Reconciliation Commission. So please give me a moment, Apoorva and Bhadra, to explain what what Justice Sanjay Krishan Kaul means when he says Truth and Reconciliation Commission. So I take you back to South Africa of 1996 when Nelson Mandela, he was trying to bring the country together. The country had been very divided because of apartheid. So he held public hearings where people who had suffered during the apartheid, mostly the blacks, they gave accounts of what had happened to them, of the atrocities. And also then the whites or people in the establishment who carried out those atrocities, they came and made confessions. So there was a kind of catharsis. Then as they made confessions, they also sought forgiveness, which was granted. So that was seen as a process of bringing back a broken society together. That's what Justice Kaul is suggesting for Kashmir as well. So why has Justice Khanna written this 3-page separate order if he agrees with everything?
He agrees with everything. Largely, the only different part that I could find there was he said that with a note of caution, as I'd say, he just says that conversion or creation of a union territory from a state has to be justified by giving very strong and cogent grounds. And he asserted that a conversion must strictly comply with Article 3 of the Constitution. But it was essentially him saying that he agrees with certain specific aspects of both the judgments.
And then we come to the question of, so Bhadra will explain to us where exactly does the judgment say, the 5 judges say that elections to the state assembly must be held by which date, and what exactly is that the judges are saying?
So basically, while refusing to go into the validity of the Reorganization Act, the judgment has actually fixed the deadline for the Election Commission of India to conduct elections in the Legislative Assembly of Jammu and Kashmir. And the date is 30th September 2024. I would just like to draw your attention, to the days when this matter was being argued in the Supreme Court, when the Constitution bench asked pinpointed questions to Solicitor General Tushar Mehta on the fact that why elections are not taking place. It had, emphasized on the need to have a valid democratic process, to start a valid democratic process in the state by saying that people of the state need to be involved. They need to be made sure that, the government is there for them. So there were deliberations during the hearing as well. And I guess that is the reason why it has culminated into a direction today. Although the bench has spoken about restoring of statehood in J&K, it has very categorically said that Election Commission of India should conduct elections in the Union Territory of J&K without waiting for the statehood to be restored.
But here I'd like to, if I can, take my headlines ke piche hat and ask you, Shekhar, because you've spoken about legal bits here, but if you could tell our viewers a bit about the political history of Jammu and Kashmir and how this order plays into the entire thing.
Well, look, political history is long and we'll not go into that. The important thing is right now, you can see reactions from Jammu and Kashmir, the political class. The reactions, you might say, in some cases it's resignation, in some cases maybe it's acceptance of fait accompli. But generally, I also see a sense of relief because this is a kind of closure. Now, Maharaja Karan Singh, who is notionally the ruler of Jammu and Kashmir, his father signed the instrument of accession. He says that I accept it. It's not as if he counts for very much in Kashmir, but the fact is that Kashmir became a part of India through a very unusual and dramatic set of events. That set of events was triggered by Pakistani adventurism, because Pakistan thought that the Maharaja of Kashmir was indecisive. Maharaja of Kashmir was also not very powerful in Kashmir. His army was not listening to him. In fact, much of his army had deserted. Maharaja himself left Srinagar, which came under threat from the raiders, and left for Jammu, leaving the elements of his army behind and his people behind. It was in that tumultuous situation the Indian government was asked to intervene. There are many books written about what happened after that. Much blood was shed. That war was fought between two governments, between two countries who both had foreign foreign army chiefs. So both Pakistan and India had British army chiefs because both of us had not yet appointed our own chiefs. We were all in transition. There was riots going on, partition riots going on in that situation. So many things were done at that point and many constitutional innovations were found. And 370 was one of them. Since then, it became an ideological argument between the Congress party and the rest, and on one side, and BJP, which used to be Jansangh, on the other. Remember, Shyama Prasad Mukherjee, the founder of Jansangh, was in Nehru's first cabinet, right? He rebelled, many others rebelled. Sardar Patel was not fully in agreement with what was going on. And since then, this was one of the binaries in our national politics, that should Jammu and Kashmir have special status or not. Now, the fact is that the Congress party never wanted this special status to continue. So it continued to dilute it. At the same time, it did not want to take it away, partly because it did not want to face the challenges that might emerge as a result internationally and otherwise, because India's international stature was also growing over time. In the 60s, it was weak. In the 70s, after Shimla Agreement, it became stronger. And then it was a work in progress. This was a good time, 2019. BJP was in power. Would the Congress have done it if they were in power? Probably not, because Congress would have liked to do this serendipitously, because that's the Congress's way. Now, you might say, oh, that's a devious way of doing it. So, very little that's been done with Kashmir or on the Kashmir issue in the last 75 years was not devious, right? Everybody. So that is the history of Kashmir, and to that extent, this takes away the hypocrisy, and hopefully, this will also take away the deviousness as well, because this will take away the most ideological, divisive element of the Kashmir issue in Indian politics. Because from now, it will cease to be a political issue, because no political party in India is talking about restoring Article 370 or restoring or putting Jammu and Kashmir and Ladakh back together. So this is something that everybody accepts. So once again, as far as history is concerned, history never ends. But I would say one chapter in history has now ended. On which note, thank you very much, Bhadra and Apoorva, for making it simpler for me. Otherwise, I would have had to spend a whole night trying to understand what the judges are talking about. Because you know what? These pages are just the summary that Justice Chandrachud had read out in the very beginning. So you can imagine how much more there was to read and to understand. So thank you very much. Both of you have made it so simpler and truly cut the clutter for me and for our viewers as well.